Hello everyone, this is the analysis of the legal aptitude portion of your LST mock test 6, which was based on the National Law University Delhi's pattern, that is the ILET pattern. Now this mock test has 150 questions and your legal section, that is part C of the paper, was a legal analysis, legal aptitude section. Started from question number 71 to 105. So let's get started with question 71. This was a question which was based on the concept of on the topic of constitution. The principle talked about the right to practice any profession, occupation and trade, just subject to some reasonable restriction. Principle 2 was talked about selling of cigarettes, which is dangerous and did not classify it as a retail sale. And explanation talked about the definition of retail sales, the most important part of the entire question, because this is a determining factor. A retail sale is the sale of goods and services directly to the end user. It includes procuring goods in large quantities from manufacturers directly or through a wholesaler and then selling smaller quantities to the consumer for a profit. So this is again an important part to be looked into. After going to the facts, we can see that these are the 4 options available to us. The correct option is option C, the maximum ticked option also. It says that he was a real estate agent and he had the right to pursue the profession. He only sold the cigarettes in his personal capacity and not as a retailer. So this is a part that we can read from the explanation that is given, because the explanation says that selling retail sale is considered when the goods are sold in smaller quantities to the consumer for profit purpose. Over here, Jeetan was not selling these cigarettes for any profit purpose. He was merely selling it to one of his clients. So this does not constitute a retail sale, hence the option would be C. Now coming to question 72. Question 72 is a question on torts. The principle says that the person is liable for all the direct consequences of his act. Explanations say that if a person is not aware of these special circumstances, then he cannot be expected to reasonably foresee a special harm. A lot of students have marked D as the answer, which says that Anand is liable since driving a scooter at high speed can reasonably assumed to lead to such a consequence. We can make a assumption only to the extent that a person's leg would break, but having a reasonable assumption to the level that he will have a blood disorder due to which his leg had to be amputated, that is a special circumstance and cannot be expected to be reasonably foreseen. Hence, D cannot be the answer. The correct answer is option B, that he is not liable for the loss of leg since he did not know that Ehsan was suffering from a blood disorder. Now moving on to question 73. This is a question on the subject of contracts. The first principle talks about the minor's capacity, and the second question says that a void contract that a minor entered cannot be ratified even after he reaches the age of maturity. That means if a person who is a minor, he has entered into a contract, he cannot bring the contract into effect after the person has attained majority. It would just be a void contract and it cannot be ratified later. So in this case also, the contract would be void because Zishan was a minor, hence option D would be the answer. This is a easy question and was correctly marked by most of the students. Now coming down to question 74. This question had a really long set of facts but an easy question. The principle was that of voluntary non-fit injuria. And the correct answer option is B, that the trainer is not liable since Amir agreed to suffer the consequences of his decision. The trainer did tell him that he should not do any rigorous exercise, but he thought of he thought the entire thing is going against his pride. His pride was getting hurt, so he continued doing his rigorous exercises, and because of which he had to suffer the consequences. So the correct answer option is option B. Now going on to question 75. Now this question is a question on the topic of criminal law, and the principle talks about abetment. The explanation says that it is not necessary that the commission of an offence, that the abettor should himself participate in the offence with the person who commits it. It is sufficient if he engages in the conspiracy in pursuance of which the offence has been committed. So in this particular question, Chacha Chaudhary, the founder of Lava Mujahid, he is the person who is plotting the conspiracy to carry out the bomb blast. So he prepares a team of 5 men. Sabu is asked to provide the materials and logistics for the attack. And Chacha Chaudhary does not tell Sabu about the team of men and only talks about providing materials and logistics for an attack in India. So we can clearly see that Chacha Chaudhary had told Sabu about the attack which is going to happen, although he has not revealed about the other members of his team, but he has clearly told Sabu that the material that he is acquiring is for the attack purpose. The team uses Sabu's criminal network and supplies to carry out the attack successfully. Is Sabu liable for abetment? The correct answer would be yes, because he conspired with Chacha Chaudhary in providing the logistics and material, because he clearly knew that the material is being taken for an attack which has to be conducted in the country. Moving on to question 76. Now this was one of the difficult questions of the mock test. It's a question from the subject of contracts. The principle is that of bailment. What is the principle of bailment says? Bailment is something in which you give your goods to another person for some particular purpose or some work, and that person would do that particular work and then either return you the goods or dispose the goods as per the direction given by you. That is the concept of bailment. Now over here the principle says bailment is an effective delivery of goods. Explanation tells you what is an effective delivery. Effective delivery means where the party is in full control of the goods and has physical or virtual access to them. So first thing is the full control, and second thing is the access to those goods. And principle 2 says that the bailee is supposed to take as much care of the good as a reasonable and prudent man would take of his own goods. Now, there was a rich businessman. He has deposited 30 kg of gold in a locker at State Bank of India, who then passes away in 2005. He has 2 sons and 1 daughter. The sons get his property and the daughter is supposed to get those 30 kg of gold. Now, the key of that locker was handed over to the daughter. When she went to withdraw the gold, both the keys were used. The daughter used one of the key and the other was that by the bank branch manager, and this is the custom with opening of the lockers. And on opening it was found there was just some family photographs and nothing else. So the daughter brought a suit against the bank that they did not take care of the goods of his father. Now the question before us is whether the bank is a bailee or whether this the entire agreement was a agreement of bailment. Now as per the definition, as per the explanation, we saw what is an effective delivery when the party is in full control, that is your bank should have been in full control of gold and it should have access to the gold. So these two will constitute effective delivery, and effective delivery is the most important ingredient of a bailment. So from the facts we can see that when you have to open the locker, both the client and the bank manager have to use the key. So that means that the bank only has a passive possession of the property. He does not have then active possession. It's not in full control of the bank. Bank merely has a second key which is required to use the open the locker. If the bank wants, it cannot open the locker and use the goods kept over there. So that means there's no effective delivery of the gold. There's no effective delivery of the goods in the locker. Hence, the bank would not be considered as a bailee. This would not be an agreement of bailment, and that is why the correct option would be C, that bank is not liable because they are not bailee in the present case. That is why C is the correct answer. Students are mostly marked A, but A is incorrect because it says that it was bank's responsibility to keep it safely as a bailee. But because there has been no effective delivery, hence there is no bailment. Now moving on to question number 77. This is a very simple question. Students have mostly attempted it correctly. It says the transfer of goods or property cannot pass a better title than what he himself possesses. So simple question. The correct answer is A, marked correctly by majority of the students. Now moving on to question 78. This was also a very simple question. We just had a little catch in the principle. The principle is that of a battery, and the principle says that a battery is the direct or indirect application of force by one person to another. Now, in the facts, what happens, there are two cousins. They had some tiff between themselves. So one of the brothers, he digs a pit and covers it with bushes so that the other, when he has come for jogging, would fall and get into the pit and get hurt. So this entire act of making the other person fall into a pit, this is an application of force, but this is an indirect application of force, because you know that because of your acts, a force would be applied and the person would be getting harmed, the person would be getting injured. So therefore this is an indirect application of force. Hence Sir would be liable for the offense of battery. So the correct answer would be option C. Now moving on to question number 79. This was also an easy question, slightly long set of facts. The topic was that of torts about defamation. So the facts clearly show that the people of the locality just wanted someone to be held accountable for the missing of the girl. So therefore they took Sher Khan's name because he has had a criminal background. Therefore the correct answer option would be A, that the people of the locality are liable for defamation because they did not have any justification or knowledge about Sher Khan's whereabouts and filed a police complaint without any cause against him. Moving on to question 80. Now again this question is from the topic of constitution. It is a slightly technical question, but only catch is in the one word of your principle, that is consultation. Principle says every judge of a high court shall be appointed by the president by warrant under his hand and seal after consultation with the chief justice, the governor, and if the appointment is that of another judge, then the chief justice of that high court. And the person would be holding office since he attains the age of 62 years. So the facts say that the third requirement, that is your Chief Justice of High Court of Saurashtra, he attended the meeting only for 5 minutes and he did not approve for the candidate to be selected for the post of judge. But still the president went ahead and made him the judge of the High Court of Saurashtra. So this appointment would be a valid appointment because the president only had to consult the chief justice, the governor, and the chief justice of that particular high court. He was not bound to follow the decision of the other judges. Hence, option A would be the correct answer. Mostly students have marked C is not valid because despite the non-approval, he was appointed as judge. So the only fact that you have to read carefully is that only consultation is required. He is not bound by the decision given by the judges. Now moving on to question 81. 81 is a question on torts. Now this principle says that if a person brings a dangerous thing or animal on his land for making profit, and then if such thing escapes and does damage, the person would be responsible even if he was not negligent. Now Amit has brought this huge aquarium for the study of the fish behavior, and due to the earthquake, due to a hailstorm, the aquarium broke down and damaged the agriculture produce kept in nearby warehouse. Now, although what he brought was a dangerous thing, it was a huge aquarium. And such a huge aquarium is capable of doing some of the other injury if in case it breaks down. But the other important thing to be read over here is that if such thing is brought for profit motive, but over here Amit has brought this aquarium for the study of the behavior of the fish, hence there is no profit motive, therefore Amit is not liable because his activity was not for profit. Mostly students have marked C, that he bought a potentially dangerous thing, it escaped and caused damage, but it was not for a profit motive, therefore Amit will not be held liable. Next question. Question 82 is on the subject of criminal law and is talking about dowry death. It was an easy question. We can clearly see in the facts that Sandeep has just asked for some help from Mandeep's father. He has asked Mandeep to ask her father for some help. There had been no other instances of injury or any demand for dowry, no other instances. This was a one-time instance and just for the purposes of help. Therefore, this option B is the correct answer, and Sandeep is not guilty of dowry death. Moving on to question 83. 83 again a very simple question from criminal law. Principle 1 talks about husband of a person cannot marry again till the time his husband or wife is living, and second principle talks about the person is presumed to be dead if he is missing and nobody has seen him for about 7 years. In the facts, it is clearly written that there was this person who went for a meeting on a ship and could not return, and the wife waited for 10 years. After that, she married another person. So 10 years is more than 7 years. If a person has not been heard for 7 years, he is presumed dead, and once he is presumed dead, the first principle would not be applied if a person marries again. So because Natasha did not hear about his husband for 10 years, she married again. She has not committed any offense, hence she is not liable for bigamy. Coming on to question 84. Now in this case, the doctrine is that of self-defense. The facts clearly say that there were some robbers in Nanjappa's house, but by the time he comes out with his revolver, the robbers had already started leaving. Okay, they were not. Nanjappa did not had any immediate threat. So robbers had already started leaving, and then Nanjappa, full of rage, starts firing at them and kills them all. So this was not a self-defense, because in self-defense you need to have an imminent threat. Over here, the robbers were leaving the house, so Nanjappa did not have an immediate threat. Hence, Nanjappa is guilty because he has used disproportionate force against the robbers. Option A is the answer. Now moving on to question 85. 85 is a question on criminal law, and the first principle is the principle of robbery, whereas the second principle is the principle of dacoity. So the principle of robbery says that at the time of committing the act, the person should be put in fear of instant death or instant hurt or instant wrongful restraint, and by such fear induce the person to deliver any property or valuable security, then it is called robbery. In this case, the family of Mrs. Verma, in whose house this robbery was conducted, they were not present in the house. So therefore, none of the factors of robbery have been complied with. The person has not been put into an immediate threat, in the fear of instant death. There has not been any instant hurt. There is no wrongful restraint. So none of the things given in principle 1 has been fulfilled. So therefore it cannot be a robbery, and moreover, if it is not a robbery, then it cannot be a dacoity, because a robbery with 5 or more persons is known as dacoity. So therefore it might be any other offense, but it cannot be dacoity or robbery. Hence the correct answer option is option D, that offense of dacoity is not made out. A lot of students have marked A as also the option, that the offense committed by Sundari and other 4 people would qualify, because there are 5 people in total. So 5 people clause is, I agree with the 5 people clause, but when it's not a robbery, it cannot be termed as a dacoity either. Now coming down to question number 86. 86 is a question on criminal law and on the topic of criminal trespass. So for trespass, it is important that the person should enter into someone's premises without his permission. But in this case, Manohar was waiting outside. He did not enter the premises, he was waiting outside the entrance of the society. And then when Tarak Mehta appeared, he beat him blue and black. So therefore he has not trespassed into the house. He might be guilty of another offense, but not for criminal trespass. So therefore option C is the correct answer. Now question number 87. Now this question is a question on torts. The principle says whoever causes injury, harm, hurt, annoyance or anything obnoxious to the community or individual by offensive of smell or appearance, or by causing obstruction to damage, is liable for nuisance. It's talking about a factory who puts its waste into the river of Kanpur. The untreated waste and remains of leather pieces are dumped into drain canals. This leads to blocking of the drainage system, and due to the complaints of the residents of the locality, although the company has installed a machine in the factory which segregates leather from other waste, but now also this residual waste is released in the drainage canal. Due to high level of inorganic waste present in the canal, the water pipeline of surrounding areas start corroding. Now residents again complain, but SIW contends that they have already taken the relevant action, cannot do anything further. The correct option is option C, that SIW is liable for nuisance because the actions are still creating problems for the residents. This was an easy question, marked correctly by most of the students. Now coming down to question number 88. 8. This is a question of torts. The first principle is the principle of negligence. The second, the explanation says that one must take reasonable care to or avoid acts or omissions which one can reasonably foresee as likely to injure his or her neighbor. Fine. Now, over here, Radha is waiting at a bus stop which is opposite a cricket stadium. Now, the cricket match was going on. The ball flies high and comes and hits Radha standing at the bus stop. So she says that the cricket authorities should raise their boundaries, should be more careful about the people around the stadium, and whether they have been negligent in the security of the people outside the stadium. The correct option is option B. Because the club authorities are not negligent, because there's a high boundary and the ball rarely went out of the club. So when they constructed the walls, they were pretty high walls, and it was a very rare chance that someone has uh, hit a six or something, that it has gone beyond the boundary. Therefore, option B is the answer, and it's mostly marked correct by the students. Now coming down to question number 89. 89 again is a principle of torts. It's an easy question. It has been marked correctly by majority of the students. Principle 1 talks about trespass to property. Principle 2 says that if an officer enters into someone's property while carrying out his duty, he cannot be guilty of trespass. So Ravi Singh was after Teja to catch him, and in the process he had to get to Mr. Singham's house. That means he would not be liable as per principle 2. The correct answer option is option D. Ravi Singh is not liable because he was performing his duty. Now coming down to question number 90. In question number 90, a divorce to end a valid marriage can be sought on the ground that the party has not been heard of as being alive for a period of 7 years or more. Now in this question, a person is there who has been taken into custody by an enemy country during a war. No one knew about him, but after 10 years, his fellow jailmates were released. So he requests them to pass the message to his wife about his captivity, that he's alive and he's living, but he's being a captive. But now, these two words, but now, that is after listening to his friends or whatever his jailmates were there who were released. After listening to them, it says, but now Sangeeta wants to get a divorce on the grounds of our mentioned principle. So up till now she was fine, but now once she's got to know that he is in such a position, now she wants to get a divorce. Majority students have marked A, that yes, because more than 7 years have passed without any information on Major Saab. Now, it's not that she did not get any information after 10 years when his jailmates were released. Major Saab requested to pass the message about his wife about his captivity. But over here, the correct answer option would be D, because he is alive and Sangeeta has that information. Moving on to question number 91. Now, a couple of very easy questions, family law. Now, in this question, it's the duty of the parents to maintain their child. However, a child upon adoption is deemed to be the child of the new adoptive father or mother from the date, and all his legal ties with the previous parents are deemed to be severed and replaced by those created by the adoption of the adoptive family. So when we look into the facts, you can see that P and Q are married to each other and they have a child named R. R is adopted by X and Y, a married couple. X, who is the earning member, dies in an accident. Can R, who is now 15 years old, seek maintenance from P and Q? He cannot, because now he has become a part of another family. Therefore, he cannot seek such a maintenance from his original parents. Hence, the correct answer would be option C. Now, moving on to question 92. Again, this is a very easy question on the concept of general principles. Every person of sound mind and not being a minor may dispose of his property at will. Now, in this case, the minor, he makes a property, but it cannot be brought into effect because he's a minor. So therefore, A's will cannot be executed because he's a minor. The correct answer option would be option D. This was also marked correct by majority of the students, so no doubt in this. Now moving on to question 93. This was a good question based on the concept of DPSP, Directive Principles of State Policy. The first principle says that DPSP are not enforceable in law but are fundamental in governance. Principle 2 says that if a directive principle of state policy to secure equal pay for equal work for both men and women. So this is the principle 2. They were also marked correctly by majority of the students. The correct answer is answer A, that is contrary to DPSP but not enforceable by a court of law. Now moving on to question number 94. This was a slightly tricky question and the students have not marked it correctly. Let's get into the facts and the principles. The principles talks about a arbitral award. Arbitral award means the decision that is given by an after you have conducted an arbitration. So this award will be rendered void if it is not in writing and signed by all the members of the arbitral tribunal. So this is the requirement. Principle 2 says that if an award rendered by an arbitral tribunal consisting of more than one member contains the signatures of the majority of the members, it shall be sufficient as long as any reason of the omitted signature is stated. So this means when you have a majority of signatures on your arbitration tribunal and then if one person is missing, one signature is missing, then the member, it would be sufficient if the reason for that missing of the signature is stated. But now when there is no reason for the omitted signature, the award is merely rendered voidable at the instance of the party against whom the award is made. So in this particular case, X, Y, Z, they were the arbitrators. Now X was out of country and Y could not sign because at the time of pronouncing he was hospitalized and suffered a massive heart attack. So out of 3, 2 will be the majority. If 2 have not signed, that means the majority has not signed. So therefore option B will not play any role now. Option B cannot be the answer because it says the award is voidable as a reason for omission of the signature is X of X is not placed on record. Now coming down to option C, it says the award is valid as a reason for omission of signatures of Y are placed on record as required by people. Now it's giving the reason for the missing of one signature, but there are just 3 parties, so the majority would be 2 and both the parties do not have their signs in place. Therefore C also cannot be the answer. Hence, the correct answer is option A, that the award is void. Because because there is no majority, principle 2 becomes inapplicable. Then we go on to principle 1, which says that any award, if it is not in writing and signed by all members, it is considered void. Hence, this was not signed by all members, therefore, it was considered to be void. Moving on to question 95. Now, question number 95, 96, 97, 98. The next 5-6 questions were easy. Question 95 is on the topic of general principles. It says no person shall be detained without being informed of the reason for arrest, nor shall be denied right to consult and defended by a legal practitioner of his choice. Now, in the facts, the person after being arrested asks for a advocate of his choice. He is not denied, but then the advocate himself, he has some prior engagement and he refuses to represent him. So Aman filed a writ petition against Bar Council for violation of his fundamental rights by a member advocate. The petition would not be maintainable because Aman never denied the right to be defended by a legal practitioner of choice. He was never denied the right by the jail. Whoever he wanted to be represented by, he was provided. Therefore, he cannot complain in such a way. Now, let's come down to question number 96. It's again a master servant relationship principle. Very easy. The determining factor is whether the act is within the course of employment or not within the course of employment. So, looking into the facts, we can clearly say that the correct option is option B, that Suresh is liable since this was an act done in the course of employment. Moving on to question 97. The principle talks about double jeopardy. It says a person can be charged and prosecuted for the same offence which relates to the same offence. In the facts, A broke open the door of a house without the consent of the homeowner. He was arrested and charged for offence of trespass. Later, it was found that Mr. A had entered the house with the intention of murder of the owner. Consequently, A was charged for the offence of attempt to murder. A challenged the framing of the charge against him for the offence of attempt to murder. Choose the correct option. The correct option would be option B because A cannot be prosecuted. Both the charges are different. Then moving on to question number 98. It says a woman married under Muslim law shall be entitled to obtain a decree for the dissolution of a marriage if the husband neglects his wife or fails to provide for her maintenance of the faithful wife for a period of 2 years. Now, in the facts, Salima Begum was married to Muhammad Sheikh 3 years after the female started to live with the parents because Muhammad Sheikh used to beat her up and compare her with other women. Now, this just means that she is still married to him and she has only gone to her parents' house, and there has been no other difference apart from this. The students have marked C as the option, that no, because she had left her husband's house. She has left her husband's house does not bring into picture the reason for the husband not giving her the maintenance. The correct answer is option A. Yes, because her husband has forgotten about her. He remarried and did not pay her any maintenance. Hence the option is A. Now coming on to question number 99. It says mere promise without consideration does not create legal binding relationships. When a person acts on the promise made by the other, it is a valid consideration. This was again a very easy question. Students have marked it correctly, majority. The correct answer is A. Ankit is liable to pay Vijay because based on his promise, Vijay had started the repair work. Now moving on to question number 100. It talks about inevitable accident, and an inevitable accident means an event that cannot be avoided in spite of reasonable precaution taken by a person. Again, a very simple question. Now, the correct answer option is option C. Sumit cannot get the defense of inevitable accident as he should have taken greater care while hunting and should have not shot the gun only when he had a clear shot at the monkey. This is the correct answer. Moving on to question 101. Again, an easy question talking about wagering contracts. The act on which the wager was made was a dog fight. So it is completely something which is uh, against the law because it is based on a future uncertain event. Therefore, something like this is not allowed. Hence, the correct answer option would be B. D. No, as contract of being betting on a dog was based on an uncertain future event and thus wager in nature. Because wager is not allowed, therefore, even such games would not be permitted. Now, moving on to question number 102. It talks about the master servant liability, the course of employment. Again, it's a simple question. Students have marked it correctly. The correct answer option is C. That the company would not be liable as safekeeping of money was not a part of Ashutosh's duty. Then comes down question number 103. Now this has three principles. Principle 1 talks about the promissory stopper, that when the desire of the promisor, the promisee has done something, that is called consideration for the promise. Principle 2, consideration must be of some value. Principle 3, agreement made without consideration is void. Now the fact says Omar rescued Majid's son from a building which was burning. Afterwards, Majid promised to pay rupees 50,000 out of gratitude. So when the act was done, then at that point there was no reward. Later, the person announced the reward but was not giving it to anyone. Therefore, Omar cannot force Majid to pay the amount because it was later that Majid promised to pay, and that too out of gratitude. If Majid refuses later, he cannot Omar to pay him. Therefore, the correct answer option is option C. No, because the labor or the act was done before the promise to pay was made. Coming on to question 104. The state shall not deny to any person equality before the law in the territory of India. This was again a very simple question but just had a slight catch in it. The butcher who's been thrown out, he is staying in a cooperative housing society. Cooperative housing society is not a government or not a state institution, and therefore on the grounds that The state shall not deny any person equality before the law, he would not be able to succeed. Most of the students have marked A as the answer because they thought cooperative housing society is a state and the person cannot be discriminated, but the correct answer option is option B, because the state is not discriminating against him. Coming down to question number 105, which is also the last question of the test. If a person doing an act that causes death had the knowledge, then it would be guilty of murder. Then the fact says that Popeye, because of seeing so much of corruption here and there, he goes to relief for relief to Barbol Baba. Now this Baba preaches humanity and encourage him, asks him to play a bomb near a place of worship and set the timer for 7 minutes. Now Popeye sees the girl Garfield and placing her bag near the entrance, and thinking that he had forgotten to take something back important, picks the bomb and runs after Popeye. So Garfield sees Popeye and runs after her, and on the way back, when Garfield reaches the main road, the bomb explodes, killing Garfield and a number of other devotees who has assembled. So therefore, Popeye over here was in clear understanding. He had clear knowledge by the act that he is doing that he is likely to cause the death of so many people and very likely to conduct some injuries. Therefore, the correct answer option would be option D, that Popeye is guilty of murder of Garfield and the other devotees. Now this brings the end to the career launcher mock test 6, LST mock test 6. This brings the end to the legal portion. I hope now that all the questions are clear, the explanation will make your doubts even more better in terms of understanding. So that's for it. Thank you so much.